work group meeting, maybe 8th. Karen's keeping this going. So we really appreciate this extra hour. What I was hoping to do with everyone's consensus to hear about one issue. We didn't get much information during our last presentation because we kind of rushed through it, but it was about a juvenile justice issue and what is the age of competency or capacity or infancy. Should North Carolina look at a recommendation to consider a change in this age based on racial inequities on who comes into the system? And then after Jackie, that we'll open it up for some thoughts, recommendations, especially on our juvenile justice issues that we have heard. I know we had heard a lot from Deputy Secretary Lassiter last week. Jackie had some ideas, and I know from our own experiences, we have some ideas. We have still on the table and issues regarding the great presentations we had on bond and pretrial and first appearances. We will come back to that. We're trying to put together everything more or less in a package, especially after the agreement in Alamance County that I think had some really good recommendations. So that will be coming up. But I thought today, if we could just kind of wrap up anything we heard about juvenile justice issues and have a good discussion as soon as Jackie's presentation's over. That sound okay for everyone?
Yes.
Any objections? Nice to see you, Senator. Okay, thank you very much. And Professor Green, School of Government, thank you for your return and love to hear your thoughts on the minimum age of juvenile jurisdiction.
Sure. So I'm starting my timer, and at 10 minutes, I'm going to stop talking no matter where I am in my slides. Okay. So I actually gave a much longer presentation last Friday to the Juvenile Jurisdiction Advisory Committee on capacity and competency as it relates to the minimum age of juvenile court jurisdiction. And I hope you guys can see that. And I'm going to give you just the quickest overview. That's not going to do it justice, but these slides are going to be available to you if you want to go back and really just digest them. I hope this is a reminder, but I'm not sure if it's a reminder for this group or not. The minimum age for juvenile court jurisdiction in North Carolina is 6, and that is the youngest minimum age in the country. We are alone at 6. Now, there are a bunch of states that don't set a minimum age, and in those states, they litigate these issues of capacity and competency to kind of figure out if kids are old enough to be in the juvenile justice system. And so those are the states in gray on this slide. And all the states that have a color on it have a minimum age in statute. So you see we're alone at 6. My old state of New York is next at 7 with Connecticut. And then a lot of them are at 10. You'll see, and a couple all the way up to 12. So that's just some framework and context for you. There are 2 really fundamental questions, especially when it comes to very young children and their participation in the delinquency system. One is, do they have the capacity to understand what they're doing is illegal? And the second is, are they competent to stand trial? And of course, competency is something we're used to a lot in the adult criminal justice system. So when I use the word capacity in this presentation, I'm talking about knowing right from wrong, knowing something's illegal. You know, does the 3-year-old who walks out of the store with the candy bar in his pocket, which he hasn't paid for, which may or may not have happened to me with one of my children, has that child committed a crime? And I think we would all probably agree, no, when you're 3, you don't know, right? You don't know that you shouldn't be committing a crime. And this idea was part of the common law, you know, before we had a juvenile justice system, when if you got charged with anything, you were prosecuted as an adult. If you were under 7, you just did not, by definition, have capacity. There was a rebuttable presumption for capacity if you were between the ages of 7 and 14. And if you were 15 or older, the presumption was you had capacity. And that was in the law until we created the juvenile court. And the very first juvenile court in North Carolina came about in 1919. And that court had no infancy defense because that court was not at all in the least bit focused on what you did. that court meshed every kid that might need the help of the court into one juvenile court. Kids who were homeless, kids who were truant or were at risk of becoming truant, kids who had committed crimes, they were all together. And it wasn't about what you did, what your history was, how serious your offense was, how long you would be committed. It was about the state providing intervention to you. So there was no infancy defense. In fact, there was very little that you would recognize of the current juvenile court in this juvenile court. And it was that way until 1967, when the US Supreme Court decided in re Galt and said, this current juvenile court is a kangaroo court, and we need to have some real protections, some due process protections for kids who are charged with offenses for which they can lose their liberty. And that is certainly the case in the juvenile justice system, right? You can get placed out of your home, you can get locked in a secure facility. So the US Supreme Court said, we have to add all these rights. And North Carolina did that first in 1969 in a limited way, and then in a big way in 1979. And that's the first time you see a competency standard in the juvenile code in North Carolina. Now, that's not the same as what I'm calling capacity here. And I'm going to talk about that competency standard in a moment. That's also where we see 6 come in as the minimum age of juvenile court jurisdiction. So the juvenile court started as this: we're going to take care of you no matter what your problem is, and moved, at least for delinquency now, to be something that, if you are in juvenile court, sometimes looks and feels very much like criminal court, especially in adjudication. Kids have due process rights. They make decisions about plea bargaining. They are working with their attorney to inform their attorney so their attorney can represent their expressed interests. And so the question becomes, as that court has moved, shifted from being a purely treatment court, no matter what your problem is, we the state are going to take care of you, to a more punitive court. Dispositions in juvenile court now are based on your history, your delinquency history, and the offense severity of your offense. That's how we calculate dispositions for delinquency now. As we've moved that way, is there a role for this infancy defense for very young children, even in juvenile delinquency? That's question 1. Question 2 is the competency standard we have in juvenile court the right one, or is there a role for developmental immaturity? So are very young children even competent to stand trial? The standard we have right now for juvenile court, for delinquency proceedings, is this standard, which is the adult standard. So the juvenile code incorporates this adult standard for competency in delinquency proceedings. And you'll see in there that you're required to have either a mental illness or defect in order to fall under the definition of not having competency. And that mental illness or defect has to render you unable to understand the nature and object of the proceedings, to comprehend your own situation, and to assist your defense in a rational or reasonable manner. Just think about young children and their ability to help their defense counsel in a rational or reasonable manner, right? We're talking about kids as young as 6. And these are some of the skills that it takes to be competent. You have to understand who's in the courtroom, who's your lawyer, who's the judge, who's the juvenile court counselor, what's their role. You have to be able to reason, like, yeah, I need to tell my lawyer what happened because then she can help me. And you have to have this appreciation, because the juvenile does have the role in a delinquency proceeding of making decisions about, am I going to testify in my own defense? Am I going to take a plea bargain? These are all things that juveniles do. So I'm going to skip over all these slides, but they're here for you, about some of the research about when kids develop these capacities. I will tell you that most of this research focuses on adolescents, not very young children, because most states don't have very young children in juvenile court. But the theme, and this is a good theme slide, is that for youth under 14, the balance of evidence suggests that they are challenged in the areas of competency. And if you have a chance to dig into some of this other research, and there's actually not a ton of it, but the research that there is will tell you that the younger you get, kind of the worse it gets. And there does seem to be a line for 10 and under, and kind of another line for 12 and under in the research. But some of that is just a function of how they structured the research studies. And there aren't very many very young kids who've been in these research studies. This is the most comprehensive study that we've had on juvenile competency. And it started with kids at age 11. So it did not even include very young children. But here it found that the 11 to 13-year-olds were much more likely to be found incompetent than those who were older than them. And this was especially true for young people who had low or borderline IQs. And I point that out to you because there is data that kids who end up in the juvenile justice system, especially those who end up actually locked up in detention or at the YDC, have unusually high rates of having low IQs. So it is quite possible that many of the young people who are in our juvenile justice system at its deepest end fall in this category of not having significantly impaired reasoning, which calls into question their competency to be really a defendant in a trial, which is the standard that we have here in North Carolina. And so the question is, one, by definition, are very young children competent according to the current legal standard? Can they do those things that I showed you that are in the statute? Can they do them? And then if it is the right standard, should developmental maturity play a role? So should it be more than just mental illness or a developmental disability that can trigger an incompetency finding, but should developmental immaturity play a role in how we define competency in North Carolina? I did it. I have 44 seconds left on my timer. That was totally insufficient to cover this topic, but it gives you an overview. I'm always happy. I've already shared my slides with the staff here, and always happy to answer your questions if you have any.
Good job. You can breathe now. Does anyone have any questions they would like to ask Professor Green in the next 42 seconds or whatever it takes?
Professor Green, I in these various discussions that I've been in with JJAC, with Representative Morey, the main issue that's come up is just that sometimes these cases where young children are brought into court are just to make sure that they have services. So that's been the concern that they have. And I just want to make sure that any recommendations that we make don't, create a gap where these kids aren't getting services.
Yeah, and I think that that's a really interesting question. Why do you have to have a delinquency proceeding in order to get services? Especially when you're under the age of 10, let's say. I actually did some work in rural Nevada where that was exactly their situation. You had to go through probation there to get any services in that community. And we did a ton of work with them to create new structures and systems and pathways for kids to get the services that they needed without going through probation. And that was a challenging place to do it because they had almost no services. So that's definitely a question to answer, but I think it's interesting that we think that kids can only get services if there's a delinquency petition filed against them.
Anyone else? And I assume services can be through Department of Social Services, community-based programs.
Well, and I'm sure, Tara, you know that a disproportionate number of the complaints we get in North Carolina on very young children are coming from schools. And so this rolls right back into your conversation about school justice pathways, school to prison pipeline. When we're talking about kids under 10, we're talking about kids in elementary school, right? So why are elementary schools feeling the need to call the police to deal with behavior that's happening in their school? And what could be done at the school and community level to provide supports and services to the students in that school, to the staff in that school, so that they have other alternatives other than calling the police to try to get help with behavior that is a problem at the school. And the offenses tend to be, largely very low level disorderly conduct kind of offenses that they are charged with. So we're not talking about kids who are hurting people, which is important.
Okay, thank you.
You're welcome. I'm going to say goodbye because I have my own child who I have to go pick up.
Okay.
But I wish you all luck, and I'm always happy to be a resource if you need be.
Thank you, Professor Green.
Sure.
Take care. Would anyone like to start there with any recommendation after her presentation if you think we have enough information. I did introduce a bill to raise the minimum age to age of 10. Last session, it did not come out of committee, which is no surprise. But I think her presentation and the competency, and Billy Lassiter also talked about it. If there are other services available for kids that need services, the best route is to find that avenue, but not to adjudicate children who are so young that really cannot assist their counsel. They can't decide if they're going to testify. They can't do plea negotiations. If we should raise our age minimum jurisdiction.
Representative Morey, since you are an expert in this, I know you've been you worked on that bill, and I'm so thankful for your efforts on that. Do you know, and I should have asked Professor Green this, and maybe she went over it and I might have missed it. Aren't a majority of the states, don't they have jurisdiction at age 12? Other states?
There was a map she posted, and it does show the most states don't have anything in their statute.
Okay.
So there's no minimum age.
Okay.
We are the youngest at 6. 2 states have 7. Most of them, I think, go up to 10 or 11, and we can pull that slide again and look at it.
Okay. I mean, I'm with you, Representative Moore. I see your recommendation here that you sent out, raising it from 6 to 10. I mean, I would love to hear from the rest of the group if they think we should do 10 or 12. I mean, from my personal experience from juvenile court, Representative Moore, and you've been there, I mean, we didn't see as many kids as that young, but again, that wasn't the appropriate place for kids to be in the first place to get the services for the kids and the families. And majority of these issues where juvenile courts were absolutely necessary and helpful for so many families was when kids were starting at age 12, right. Middle school. So.
And I would draw us back, we have the statistics from Mr. Lassiter on the overrepresentation of young youth of color receiving complaints, very disproportionate to the racial profile of our state. So we'll always tie that back in, but I think it was 71% of the incoming complaints involve youth of color. But we can
and I believe the other thing you pointed out, Representative Murray, was that majority of the offenses were all school-based offenses for those kids. So, I don't know, Commissioner, what are your thoughts?
I was just sitting here looking at this map, other states, when they talked about no minimum age, and I think I counted about 22 states, and then we're sitting there with the age of 6. You know, whether it moved from up to 10, 12, you know, and I also look at males have a tendency for its maturity is to mature a lot, females a lot faster than males. And so I have to agree that 10 or 12 is we got to at least move it to that one of those numbers.
Tara, do you have thoughts?
So I guess I'm wondering if it might be an easier lift to just have no minimum age, because I worked on different legislation that it was omnibus bill that had I think 9, and there were just sticking points. People had, you know, having a specific number identified, people just, well, I really think it needs to be, you know, 7 or 8. Like, we had a lot of pushback, you know, from our more conservative friends, and I flagged the conversation with DPS just because that was their main concern about raising the age. So just to, you know, get all our I's dotted and T's crossed to make sure we're not, you know, facing the same criticisms next year.
Yeah.
Jim?
For me, I guess, you know, I'm fine with 10. I might be fine with 12, but I'm certainly fine with 10. I think the idea about having no minimum, I think there's some merit to that. It might make it a little bit easier to get a bill through.
I'm just worried if we say there's no age, habits have been formed and districts will continue to do what they do. I mean, I remember in Durham, a pencil throwing incident with a 6-year-old. And, you know, if they feel there are no services, it's the easiest way to get a kid through a court and get services. I mean, very rarely did attorneys bring up capacity or competency. And there were many times they should have. I mean, it was clearly the child had no concept of what was happening, but they just wanted to get services. So, I mean, Tara, I totally agree with you, but I just think if we set a floor, then these frivolous petitions won't be coming in, especially from schools. And I guess I agree with Senator. I think we will be doing ourselves here if we get at least out of 6. And I think to be palatable for people, probably 10 years old would be much better to fly than 12.
The only thing I want to say, Representative Moore, is like the whole thing about this task force. I feel like it's supposed to be some sort of guidance. What's the right thing to do? Inspire folks to make better choices, whichever branch of government it is, or whichever departments and agencies that we're working with as far as law enforcement. So I'm full agreement with you. We've got to at least raise it to 10. My only thing was it should be 10 to 12. But I mean, if consensus is at least for 10, I'm fine with that this time.
I'm good with 10.
Okay. Everyone sound okay? And I agree, Senator. 11-year-olds are still 5th graders. 12-year-olds sometimes are 6th graders. So we're still talking elementary school age kids. I don't want to control it, and I want to be aspirational too. Do we have objections to do a recommendation to 12, knowing we may get pushback? Or
again, Representative Moore, my thing is if we were to recommend 12, we know folks will drop it down to probably 10. Like, maybe we could settle with 10. That's just the way it works in Raleigh.
Okay. How about our work group? Could we have a consensus? It's 12 years old, knowing it may be debated some?
Yeah, I'm fine with that.
I'm fine with that.
I'm fine with that.
I'm great with that. Okay, thank you very much. Appreciate it. Now we're kind of wide open. There were some other issues that did come up, and I sent you just at the last minute some just of my ideas to try to look at. I do want to save some time. There was a big case out of the Court of Appeals yesterday that I hope we can address. We did hear about, now that we have raised the age, that automatically any 16, 17-year-old who is charged with an A through G felony can go to the Superior Court system. And I think Professor Green, and I think Billy touched on it, we have some prosecutors that don't ever take these kids to juvenile court. There's never anything other than a grand jury indictment puts them up in the Superior Court system. Thinking of that, and then also sometimes they get to Superior Court and the prosecutor and the defense attorney tell the judge, we would like to remand this back to juvenile court. The kid was with someone else as armed robbery. He was a co-defendant, but we can't serve him in the adult system on probation for a felony, but he could get a lot more in the juvenile system. So one of the thoughts, and some of the advocates had suggested, with raise the age, we're saying the age of jurisdiction is now 18. 16, 17-year-olds should go through the juvenile court process. That if there's a finding of probable cause and the statute says then you automatically transfer, you do that. But you don't sidestep juvenile court by going through a grand jury indictment. So a proposal I would say is that the grand jury process would not be part of the criminal process in the 16, 17-year-olds charged with A through G felonies. It has to go through juvenile court, a finding of probable cause, and then a transfer.
Of course, and I'll speak up, obviously, the DAs. I was the one who suggested this in the Youth Accountability Task Force years ago, and that's still my position. I think we need the ability to indict 16 and 17-year-olds and A's through G's. It was debated at the Youth Accountability Task Force, and we did it all again in the legislature. And so I know district attorneys and law enforcement will be heavily opposed to pulling that out. So I am opposed too, because I actually this was what I recommended to the Youth Accountability Task Force.
Okay.
So, Representative Moore, we heard from our academics who came and spoke to us and some of the other experienced folks, and they talked about how, yes, we've raised the age, but it's business as usual, it seems like, with our 16 and 17-year-olds with these felonies. Again, we know the data, the science is there. The brain is still developing until you're 25. And you reduce recidivism rates if you keep folks in juvenile court. And if you provide a process to make sure that we keep the kids that need to stay in juvenile court, I think we'd be better off as a state. So I would think when we talked, Professor Green talked about this last week as well. It's worked in our state really well when we had it for juveniles, up to 8 class felonies where you kept them in juvenile court. You had a probable cause hearing, then a transfer hearing. It worked fine for our 13-year-olds, 14-year-olds, and 15-year-olds. So why can't it work for our 16 and 17-year-olds all of a sudden? 24 months difference from a 15-year-old. I would recommend that's the route that we need to go, as you recommended here. With all due respect to
I've got to push back on that, because I think there's some, number one, they didn't present us with very much data in that meeting. They didn't even know which districts they were talking about, and they didn't even know what the process was for getting an indictment. So number one, I don't think they presented us with much data. And number two, I don't think it's worked so well in the opinion of a lot of people across this state. Your own jurisdiction, Mecklenburg County, was one of the reasons, because of some history they had there, that this was put in to the statute. And I know that was probably before it may have been before you were even working there. But just that gives you some history. There were a lot of folks across the state who didn't think the probable cause hearings in juvenile court worked very well and served victims, especially victims and their families. And I've been here 31 years, and I don't know that we've ever, knock on wood, that we've ever transferred anybody over. We may have, but now with 16 and 17-year-olds, we've got a few cases that we're now looking at. And the probable cause hearings, we did a probable cause hearing a few months ago that was about 4.5 hours, a probable cause hearing. It was a trial, which is not what a probable cause hearing is supposed to be. So I've got to push back that it's something that has worked. I think there are a lot of stakeholders out there who don't believe it has worked that well over the years.
Tara, would you like to give us your opinion?
So we debated this at length in the JJAC Legislative and Legal Committee, and it was basically this conversation identical. Heather Traska is the ADA in Mecklenburg, and she was very clear that she couldn't support this on behalf of herself and the DA conference. But then, the other side was making the points you are, that it's better to start in the juvenile court because it's harder to come back once you've been in the adult court. So I have seen both sides play out. I agree that if we make this recommendation, the DA conference is going to oppose it. That's a reality, but I certainly see, the merits for it.
So DA Woodall, it sounds like one of your main issues with it is essentially it would overwork the DA's offices. With your limited resources.
I didn't say that.
No, I'm just trying to understand, because you're telling me a probable cause hearing might last you 4.5 hours.
Well, my point is, I've been prosecuting for 31 years. I've done adult probable cause hearings in every type of case you can imagine. I've never had one that's 4.5 hours. Yeah, that's what we're doing in juvenile court. So it's not a probable cause hearing, it is a trial. And it's the judicial decision is being made as if it's a trial. That's not the standard for probable cause. And I think district attorneys are elected officials, and I think this is one of the abilities we should have is to indict 16 and 17-year-olds. This was something that we debated and debated at the Youth Accountability Task Force level. It was debated in the legislature. And I'll just tell you, I think you'll have virtually every district attorney and every law enforcement agency in the state will be opposed to this. But I mean, you can make the recommendation. It's just going to be, this is one that they're going to really push hard.
So DA Woodall, just try. So at the end of the day, my point is trying to keep the kids in juvenile court, right? Because I believe, from my own personal experiences and seeing what I've seen, that that's how we build people at the end of the day. Instead of building prisons, it contributes to public safety. So my whole point is, with 16 and 17-year-olds, we've got to actually treat them. Kids are kids, so they need to be treated like kids. And I get what you're talking about as far as the process in juvenile court. But what I want to get from you, what I'm trying to figure out is, at the end of the day, do you believe that we need to keep these 16 and 17-year-olds in juvenile court, or do you think they should go to adult court?
There are some, and number one, it's not. Wait a minute. It's not an automatic. We keep saying automatic transfer. It's not automatic. You've got to indict them. So we look at these just like we do any case. This automatic should be taken out of there because it's not automatic. I think there are 16 and 17-year-olds, and I've dealt with them. Some of the most hardened criminals I've dealt with are 16 and 17-year-olds. Not a lot of them, but I have had some. And remember, we've never transferred a juvenile in my time here to Superior Court. And we're only going to do it if we feel like it's absolutely necessary. But I think we should have that ability, and we should be able to indict 16 and 17-year-olds on A through Gs. And I don't, there are some districts that the DAs may look at it differently. But again, this was really debated over and over again. And this is where we came out. And I think, it'll be a big fight if you try to change it.
I understand that. Go ahead, Representative.
An alternative was to, leave the indictment process as it is. Some of us feel differently, but to allow prosecutorial discretion to take a plea in juvenile court on an A through G.
Right.
Would you go along with that?
Oh, yeah.
So saying that, if it's in juvenile court and if we found probable cause, but a prosecutor could say, we're going to take a plea here in juvenile court on an A through a G if we feel it's appropriate.
Yeah, and I'll tell you something else that I think really affects this is the 90 days that we're trying to work with to get these cases indicted or probable cause within 90 days. And I'm not saying that needs to be changed. You need to have a timeline there, but I think that may be one of the reasons you have a lot of these cases moving to the adult system that, frankly, if they took a little bit longer to look at, would probably never go into the adult system or shouldn't go into the adult system. That's another thing we've encountered here now that's really different. We're getting some push, especially in some real serious cases. We've got to do something with them. And that 90-day, a judge can continue that so it can go longer, but that 90-day rule really keeps our back against the wall in juvenile court more than we thought it would.
Commissioner Smith, I don't want to leave you out. Do you have any comments, sir?
Actually, this is a learning process for me. It's not my expertise in this area, but I'm learning, and as each individual discuss and talk about what they really truly understand. Like I said, I've never really dealt with the juvenile system, actually understanding how it actually works. So, I'm going to have to go with whatever the majority of experts think the best way to go on this one. I just don't have the background in the court system to understand. I can understand it, but not to the point that I can make any decision like that.
Well, and it is a big issue and it's a complicated one. I think everyone has great points. This was debated quite a bit when we passed Raise the Age just 2 years ago. And I think maybe we should take this off the table unless we did get any more information I think the senator and I feel similarly on it. But I think Jim's right. If the DA's conference says, you know, this is a definite no, that we've litigated this, argued about it, we got raised the age, and this is where they stand. But a proposal could be that, I don't think it's in the statute now, but DA's discretion, they could accept any A through G pleas on a 16, 17-year-old if that's the prosecutor's discretion. Would that be a proposal we could send forward?
Yeah, I'm fine with that one.
And we can come back to it, Senator.
I'm
Sounds
fine
good.
with that
Sounds
also.
good, Representative Moore.
Yeah,
Okay.
I'm fine with that.
Let's get to the juvenile life without parole, if we can. And Chris Parks with Disability Rights is on here. Justice Earls?
Yes, hi, sorry. I've just popped in to say that in light of this potentially being an issue in front of our court, that I'm gonna hop off now, and I'll just ask Jasmine to text me if you return to a topic that isn't gonna be litigated in front of our court anytime soon. So just to be clear, I'm hopping off for that reason.
Okay. Thank you, totally understood. We appreciate it. So last time we heard from Preston Shipp for fair sentencing of youth. And what we know, and it does get kind of complicated with the Miller decision from the US Supreme Court about it's unconstitutional for mandatory life without parole, followed by Montgomery decision. And in North Carolina, we've never done a fix to be in compliance with the last Supreme Court decision. There was a case that came out of the Court of Appeals yesterday, a unanimous decision that de facto juvenile life without parole on life sentences is in effect a life without parole if they have consecutive like 25-year sentence, and they're not eligible for parole for 50 years. And the court ruled that that young man deserves a new hearing. What I'd like to do, and we introduced a bill once again to give any juvenile who's gotten life without parole, life with parole, the ability to go before the parole commission within 25 years, regardless of the boxcar sentences, regardless of the sentence. But kids are redeemable. They can be turned around. A juvenile who is 13, 14, 15, who commits a serious, horrible crime, within 25 years, that juvenile should be able to at least go to a parole board, present the case, and be admitted parole or denied, as many other states have done. We heard Mr. Shipp say 26 other states and DC have done fixes. North Carolina is handling these cases one at a time. They go up, they get appealed, they go back down for resentencing. It's costing millions of dollars. And if we can have discussion on it, Chris Parks is the expert. She helped write the bill, House Bill 877 on it, and she could probably give a little better explanation or is here to answer any questions about it. But a proposal to look at the governor's office enhancing his clemency capabilities for any juveniles that have received life without parole or boxcar sentences, that there could be consideration of clemency from the governor's office after a juvenile has served so many years or decades, or to support legislation that would give the right to parole at least within 25 years. Some states have done 15 years, 20 years, 30 years. I mean, it's a wide range, but I'd open it up for discussion, and Chris Parks is available for any further information. Chris, you want to fill in where I left off?
Okay, can you hear me okay?
Yeah.
Okay, sure. And just to remind everyone that the data that Ben Finholt shared with us, what Preston Shipp said is that nationally about 70% of the kids that have life without parole are kids of color. In North Carolina, it's 91.5% of the kids that have that are sentenced to die in prison. And in both of the possible resolutions that you have for this committee, nothing is going to compel the release of these people, but it just gives them not the right to parole, but just the possibility of parole review. In trying to figure out in North Carolina how to respond to the Montgomery decision, when Miller was decided in 2012 by the US Supreme Court, it took 10 days for the legislature to come back and change the law so that we're compliant. And we still haven't done that in North Carolina. The way that Montgomery changed it was the court kind of said, we're actually really serious about this. Only the worst cases and the kids that are irreparable, that will never be any better than they are today, those are the only kids that should get juvenile life without parole. And North Carolina just hasn't responded to Montgomery. And so there were a lot of ways that we could have done this, but they were really quite expensive. They would have involved a lot of post-conviction appeals and a lot more appeals than we even have now, with these cases going back and forth to the appellate courts. And then the judges have to decide, a kid that's 14 or 15, is this kid ever going to be better than what they are today? And that's a big burden. And it's a really hard standard for the legislature to come up with, is, what is irreparably corrupt? And so we did what other states like Arkansas, I think Preston talked about West Virginia, and now Virginia have done, which is just give these kids an opportunity for parole after a certain number of years, because that brings North Carolina in compliance with Montgomery, but it doesn't add a lot of cost for other hearings and trying to define, who is irreparably corrupt. And as the decision in Kelleher says, and as the Supreme Court said, nothing compels release of these kids. It's just, if they get in prison and if they rehabilitate themselves and show that they can be a meaningful addition to society, it's kind of like Eric, who spoke to this group last week, then they would have an opportunity to be paroled one day. And it's that hope that I think makes the difference for the courts that have looked at this. So that's the legislative fix. And the only thing I will say about the other idea, and I assume everyone's gotten a copy of the executive order. The legislative fix is something that this committee could recommend or this committee could support, but an executive order is something that this committee could request that this governor do that could happen right now. And that if the larger task force is going to sort of beef up the clemency office, this would be part of that. And it would just be some training and some special folks that work there and special provisions for juvenile cases that come before the clemency office. So that's something that would be a little more and a little could happen much sooner than just supporting legislation. So those are two options.
Thank you very much, Chris. And I don't know if people have gotten there. We have a draft of what an executive order could look like for the governor's office to establish a juvenile sentence review board, that juveniles that have served at least 25 years or the minimum term required by law, had all the sentences of the current term of incarceration been run concurrently, that these matters could go to a clemency review to see if they would be eligible. Not saying they would be, but so kind of two approaches, one a legislative, one an executive order recommendation, both or neither. But I do think it's upon us to come up with some recommendation, because we need to be in compliance with Montgomery and now what this Court of Appeals ruling was yesterday.
Yeah, I've got a question. When we started doing the Miller hearings a few years ago, so they don't put us in compliance with Miller and Montgomery, because I thought that was what we were doing.
Go ahead.
Yeah, I think that the hearings are in compliance with Miller, but not in compliance necessarily with Montgomery. Because if you look at the appellate, what the superior courts are doing and what the appellate courts are hearing, the superior courts all just have sort of a different idea of what is irreparably corrupt and incorrigible. And then the appellate courts have a different, sort of have all these different standards of review of those superior court decisions. So we're just, as the lower courts are doing these hearings and they go up for appeal, we're getting a lot of really differing messages from the appellate courts.
And they're coming back one by one.
Right.
Coming
Well,
back.
they're not all coming back.
No, they're not all coming back.
Yeah, there are a lot of them that haven't come back. Yeah, I guess, here's my concern with, we've told families where we've had a Miller hearing and a family of a victim's told this juvenile has now gotten their second life without parole sentence. We're in compliance with the Supreme Court. I feel like that's a promise to the victims' families. They live with these when it's a murder. They live with that every day for the rest of their life. The fact that their loved one is murdered. And again, and a couple of you are going to know exactly who I'm talking to, one of the most hardened criminals, most vicious killers I've ever prosecuted was 17 years old. And, I've told his family now he's got life without parole. We complied with the Miller hearing. It went up. It was affirmed. So we've promised them that this particular kid's going to stay in, again, he's so violent, is going to stay in prison for the rest of his life. I think where we've done these Miller hearings, my position is I'm opposed to going back and looking at those cases. The other parts of this, I don't have any problem with, but where we've put families through this, I don't want to go back and look at those again.
Representative.
Yes, sir.
I'm sitting here, I'm listening, but I'm also looking at the statistics. And I'm a Black man. And anytime I sit and hear that 91% of individuals in North Carolina have been sentenced life without parole, and they look like me, I have a problem. Now, individuals, yes. But when you start putting everybody in the same category, I don't know how many of those 91% people are guilty or innocent, or if they had the legal representation. But I think every person, we're in a humane society, every person should have the opportunity, unless proven, by experts that they cannot be rehabilitated. But other than that, we have a big issue here, and I'm very concerned about it. And yes, you could have one or two people or whatever the number may be that you feel that, for the crime that they committed. And I understand, and I have a lot of sympathy for the victims, and I understand they're living with it day in and day out. But each of those individuals have been sentenced life without parole does not fall in that category. I will be willing to say that would be interested in knowing, what are some of these crimes? And then on top of that, I sit and listen to Eric last week. I had tears in my eyes. Very articulate man, spent that amount of time in jail, but he still had an opportunity somewhere along the line, because he was in Tennessee, that he was able to redeem himself, come back and be a family man and be productive to society. He couldn't have been too bad if he's out trying to help others to prevent them from going down the same road that he just, a life is very short, and I think that we need to give all these young people the opportunity that we've been blessed with, and that is to live in a society, in a community that if we make a mistake, that we can redeem ourselves, with time. That's where I stand on that one. But like I said, I'm very disturbed about the 91%. It hurts me.
Representative Morey, I'm completely with the commissioner and the recommendations that you provided here. Look, I mean, both these recommendations talk about eligibility. Doesn't mean it's going to happen, right? And like the commissioner talked about, I mean, let me just reiterate what Preston said from last week. He said the United States is the only country in the world that sentences a child to die in prison. He said, we claim to value second chances and stories of redemption, but we're hypocrites. A Black kid is 10 times more likely to receive life without possibility of parole. 23 states and the District of Columbia ban life without parole for juveniles. So we're not saying that folks are going to be automatic parole. We're saying, folks, if they paid their debt to society, if they've changed, I mean, obviously, if you're a juvenile and now you're a 40, 50-year-old man, I mean, you've had time to grow, I would think, while you've been incarcerated all that time. And keep in mind, you have to think about this for the rest of your life, about what you did. And you will continue to deal with those collateral consequences for the rest of your life. So this is simply about eligibility, giving people an opportunity to be heard. That's what America is. It's about having an opportunity to be heard. So I wholeheartedly support your recommendations as with respect to juveniles without juvenile life without parole, number 5.
And Tara?
Yeah, I completely support them. I think that this is totally consistent with our state's recent recognition that, juveniles' brains are different. They don't have the capability to really reason like they should, to have achieved the level of competency that Jackie was talking about. I think the fact that this is just a recommendation that they should be able to be before the commission is, I mean, somebody we all know who DA Woodall's talking about. He's not going to get parole. I think, really ensuring that we recommend, maybe Prentice and Eric come and do really, really thoughtful training with the parole, so they really are able to, make good decisions about who should be eligible.
Well, and I will say, after 18 years as a judge and 10 years as a prosecutor, I could never predict who was going to be successful and who was not. If we sent them to training school, and some of the ones I thought were incorruptible or they would never be redeemed, I've seen them many times, and they're fabulous young people. And some that I thought would do very well turned out to continue to commit crimes. But I agree with these proposals, especially because the racial inequities and the lack of human intellectual development. And I strongly support it as well. Jim, is there any thing that could be tweaked or looked at that would make you more comfortable with this?
The only thing that I would agree with is if it were that it does not apply to those juveniles in prison, life without parole, who have been through Miller hearings, and those hearings have been completed. They've gone through the appeal process. I mean, I hear what everybody's saying, but these are all cases where you've got first-degree murder. If it's a premeditated, not a felony murder, like as was described in our last meeting, because I think that was a felony murder that Mr. Alexander was convicted of. I think where it's premeditated and deliberated, that's a different crime for me, because again, the victims and the victims' families live with that for the rest of their life. They don't get to go before any commission and have it undone. And I've sat with them and I've cried with them too many times to count. And I've been through these Miller hearings, and it's important to me that we made a promise to the victims' families, and I'm going to fight as hard as I can to keep that promise where we've gone through those hearings. I told them I would do that, and I'm going to do that.
Well, and they're always welcome to go to the parole hearings, and they take great weight with the victims.
My position is we shouldn't put them through that again. We've taken, their loved ones been taken, they've suffered every day. We shouldn't put them through that again. So.
Okay.
I guess if I can interject, I totally understand what you're saying, Mr. Woodall. And the Kelleher court that decided this case yesterday went into a lot of detail to talk about how hard their decision was in lieu of what the victim's family had testified in the statements that they had provided in that case. But what they said was the most important thing to look at was that the person was a juvenile, and that had to come first under 8th Amendment and under our Constitution. And I think that the law is going to have to be changed to comply with Montgomery. And I mean, I understand if this is your job and if it's not something that you can agree to, but I think the law is going to have to change. So if there are ways that you can think of that would make it more palatable, I think that'd be great. As far as the clemency goes, whether you guys recommend that there's special expertise in dealing with juvenile cases or special people there to deal with juvenile cases, you know, the governor can grant clemency to anyone at any time, whether you have life without parole.
And I tell my victims' families that.
Mm-hmm.
I tell them that. But I do think that the issue is really a different issue. The boxcard sentences and the life without parole, de facto life without parole. I don't have an issue with that. I only have an issue where it's premeditated, deliberate murder, and we've been through Miller hearings. That's where I have a problem. I mean, again, I've told those families I'd fight to the end on that. I'm going to fight to the end.
Sometimes you wonder how much premeditation can a 16, 17-year-old have?
Well, in my particular case, he had a lot. He was the leader. He planned it. He had a lot.
Well, I've seen those cases too, but it doesn't give the rest
And
of the.
he killed somebody else too. He killed 2 people. So.
Oh, I know. We started in Durham.
Right, and even his own family.
Yep.
Says he's where he should be because he'll do it again, and he'll do it again. And I'll never be convinced otherwise.
Always be an outlier somewhere. But I think we're looking at the whole.
Well, I understand that. I've just got to tell you, that's my position. I promise these families that this is something I'd fight for. I'd fight with them to the end. Well, you know, and I'm going to do it.
And we appreciate that. But I think we do have a consensus, not unanimous, that we would send these 2 recommendations, one of the possibility of clemency for juveniles and a special board to hear these within clemency, and to support the legislative change that juvenile life without paroles or boxcard sentences de facto could be eligible for a parole hearing in 25 years. Are we okay with those being sent out and seeing, and who knows, we don't know where the task force will go. The only last thing, if you don't mind, Eric Zagreb did speak to us. The other groups are looking at the role of SRO officers. And he was wondering if we would support consensus that we at least study the role of SRO officers in terms of protecting the school from outside safety, or what is the inside threat. Are too many kids being sent to court because of the role of the SRO officers in a racial disparate way? Asked to do a study on that. That's kind of as vague as it was, but I said I would present that and see if you all agree that work group 3 thinks we should look at the role of SRO officers in schools.
Representative Moore, I don't have a problem with that study, but I feel like we already know the answer to that.
Yeah.
So I'm not sure how much of a study is needed to confirm what we already know, but I would be fine with the recommendation to support a study.
Well, I have a question. My concern is, we pretty much know what the result's going to be. I mean, we looked at the number, I think 77% of the kids there are minorities. But my question would be, what we're going to do with the study when we get it? You know, how that going to change, you know, these statistics? And that's what I'm concerned about, the statistics itself. And did he say any more about the study? How would he bring something in that some of the experts haven't explained to us yet?
Yeah, Commissioner, he said support a SRO impact study to review the danger of threats outside of the school versus threats or dangers on the inside, break down the school complaints by SROs to the administration or the teachers, the race of the complainant and the juvenile, and interview students of their impressions, feelings. One response I gave to him would be a proposal that SRO officers could not take out juvenile court petitions unless signed on by the school administrator or a social worker at the school. So it's not just a law enforcement decision at a school. They must have agreement and sign on by the principal or the social worker. Anybody like that idea? Or
Yeah, that makes sense to me. It's pretty consistent with the school justice partnerships.
Works for me, Representative Moore.
Yep, I'm okay with that.
would you be okay, Commissioner?
Yes, ma'am. Yes,
Okay.
ma'am.
So the proposal would be that any referrals by an SRO officer working in a school could not be filed in juvenile court unless also signed by the principal administrator of the school or the social worker. That sound okay?
Yes.
Okay, cool. Anything else? I don't want to keep you any longer. Natalia, you've been quiet. She's done a lot of behind the work and appreciate everything. Anything you'd like to?
No, just trying to keep up. I am a little confused on the SRO thing, so I might just need to follow up with you offline about that.
Sure. So Friday, we will have our big task force meeting. As I said, our package of bail and pretrial will be coming up later. So we're still working on it. We're not going to get it out by this Friday, but we will be getting it out shortly thereafter. And marijuana, we're still going to look at marijuana.
Representative Moore, again, thank you. And again, thank you to my fellow work group members. I just want to say, look, I enjoyed the dialogue today. A great conversation. DA Woodall, respect you and appreciate your input. But I just want to say, look, I'm on this task force because I want to be able to help, you know, close this racial equity gap and have a fair criminal justice system for all people. So I hope at the end of the day, we all know that we're all acting and talking about these issues in good faith. And we just want what's best for our state. So thank you, DA Woodall, and the rest of my folks.
Yeah. Thank you, Senator.
Representative Maury, I'm sorry, I just wanted to make sure, this is Jasmine, that the working group was aware of the new meeting that was added on, you should have received a calendar invite from Ashante Pretty for October 21st at 4:15. That's that meeting we talked about related to victims of color, trauma, and restorative justice. And we plan to invite other task force members to attend that meeting. And so I hope that everyone will be able to make that meeting. We're very excited to have some national speakers, including Danielle Sarid, the author of Until We Reckon, coming to join us. So
Great.
That's it.
Yeah, thank you, Jasmine. And I forgot to mention that, and especially addressing victims. We need to do that a part of this work group and the task force. So we really appreciate that. So without any further ado, really thank you for all your hard work, everyone's respectful conversation, dialogue, and we'll see you on Friday.
Thank you.
Have a good night. Thanks.